Next case is Souare versus Guzzo. We only have one party here today, the appellant. He's present in the court. You will have 15 minutes to present your arguments. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, and victims during your argument if that applies here. If that does apply here, you can refer to them by initials or terms like the child. We've read your brief and we're prepared to proceed when you are. If you want to step to the podium, you may proceed when you're ready.
Thank you. So, my name is Elhadj Souare. So, may I please the court? My name, the trial was before at the municipal court. There's no testimony, there's no findings, and there's nothing, absolutely zero in the record to support the trial court of $6,000. There's simply reversible error. This is a void judgment under the Tom King and controlling 9th District prison. The court must reverse and render the judgment in my favor. The record is complete. The records contain no evidence, not one exhibit, not one witness, not one document to prove the $6,000.
Was there a hearing at the trial court at some point?
Yes.
And that was in front of Judge Kimbler, as I understand?
Yes.
Okay. And what you're saying is some of the stuff before Judge Kimbler, as I understand, didn't support that you owed your attorney any money. Is that what you're basically saying? Okay.
Yes.
And that decision was appealed at some point in time.
I did. It was too late.
Right, and it was too late.
Yes.
And that what your first assignment of error sounds to when you talk about due process and not getting notice of a hearing?
No, the due process is he left the court.
Judge Kimbler.
Judge Kimbler left the court. He was asking to the other party if I'm paying child support, not listening to me, not listening to the evidence. That was
And that, where that occurred,
inside.
is there a transcript that I can look at in the record before it where I can see Judge Kimbler asking you these questions?
That's what I asked the municipal court to do the App.No to bring all the record so you can see it. But if you go to the docket, you see one of my motions to open the case was the Judge Kimbler left the case. He was asking me like nonsense questions. So, and then he said he's tired to listen to me because I'm not understanding. He's trying to make me understanding that every judge or every attorney has to work like that. And then if on the testimony or the money he said I owe her, it was overcharged to me. She said I owe her $100 and something thousand $100, and then he received $3,000 from me, and then he withdrew herself half of the case at the family court, and then she overcharged me by texting, and then later on she said on the email, she said I did not text you, I did not charge you for emailing or calling other parties, and then on that menu she said she even charged me for texting and calling. Contradictions.
And those are some of the exhibits you're talking about that aren't in the record.
Those exhibits is on the I put on the appeal court, and then there's on the municipal court. They did not bring it to you guys.
So you have assignment of error number one. You're saying the trial court violated your rights by failing to issue a final judgment. What final judgment did they not issue?
So they issued the judgment. I did not receive any mail to notify me that he did.
The Judge Kimbler decision?
Yes, decision. Okay. And then that's why later on you guys dismissed the case because it was over past due, if I'm not mistaken.
I think you're accurately saying that how that case was dismissed. The next case will go back and you filed a new trial for reconsideration.
Yes.
Did you get notice of that decision?
No.
You didn't get notice of that decision either?
No.
How did you appeal that?
So I received, I came back to the court, I filed a motion, and then they said since the judge, I had a conflict with the judge, and then they bring, I don't know who was it, somebody judge, they said from the Supreme Court, Ohio Supreme Court did it. And then when I received a letter from him, and then saying, oh, this is done, there's no mistake from the judge. And then I came later when I asked them, I didn't even find that decision, any notification on the docket. And the municipal court told me it take like 2 or 3 weeks. I don't know if something, IT issue. I said, okay. And then by the time their IT issue, I already appealed.
Okay.
Yes.
So you were able to appeal that second decision, that's what we're here on now?
Yes.
There's no argument that's late that I can see.
Yes.
Okay, go ahead, continue. I want to make sure I understood that. What you are.
Yeah. So there's no $6,000 to support that I owe her money. There's no evidence either. I think that's bias asking me when I go to the attorney asking me if I'm asking her if I'm paying child support. That's ridiculous. And then leaving the court while it's going on, telling me he's tired. And then he even came late. So I don't know if you guys are going to ask them to bring the evidence, because I put some evidence in the municipal court, and then you got even, I think it was you, Scott, George Scott, I think you denied one of my motions. Thank you.
I know some of your motions are denied, I don't know if by me or not on that. And I know you have some pending motions right now regarding questions about should evidence be performed or not. So we'll look those over, well, obviously, and decide those.
Okay.
Do you have anything else?
No, that's it.
Thank you for your presentation. The court will take this matter under advisement and issue a ruling in due course. The clerk of courts will mail you a copy of the decision on the day it's released, and also our decisions are posted on the Ohio Supreme Court website. Thank you again.
Thank you.
This court is now adjourned until